All right, counsel, are we ready to proceed with the receiver's report to the court in T16-00041 Canton ISD versus Barry et al.?
Yes, Your Honor.
All right, I'm going to go ahead and ask for appearances for the record, and we'll begin with you, Ms. Seifer.
Yes, sir. I've prepared a kind of a summarization of what has transpired. Is that okay?
Well, before that, I just want you to announce who you are for the record.
My name is Paula Cipher. I'm the receiver.
Can you spell your name, please?
Cipher, S like Sam, E-I, F like Frank, E-R.
And just for the edification of those involved, we are on the record today. Court reporter here with me in the courtroom who will be transcribing everything that is spoken in court today, and there will be no recording of this proceeding here today. Go ahead, Mr. Brand, announcements for the record.
Your Honor, plaintiffs are ready.
And go ahead and state your name for the record.
Richard Brand, I represent Van Zant County et al. And all of the taxing entities.
And all right, you're going to have to repeat that because your audio is cutting out. Mr. Brand, can you repeat that? Your audio is cutting out. My court reporter can't hear you.
Yes, sir. Richard Brand, I represent Van Zant County et al., which includes all of the taxing entities in the case.
Thank you, sir. Mr. Elliott.
Joel Elliott on behalf of Robert Abrams.
Mr. Monning.
I am Prater Monning. I'm co-counsel with Mr. Elliott for Robert Abrams.
Mr. Shackelford.
Raymond Shackelford, attorney for Dustin Williams and his entities.
Thank you, Mr. Shackelford. All right, Ms. Seifer, go ahead and present your report to me, please.
Yes, sir. I'll start from the very beginning. In late November of last year, I received a call from Prater Monning. He had asked if I would be willing to accept an appointment as a receiver in another tax case in Van Zandt County. I had worked with Mr. Monning last year on another ad valorem tax case in Van Zandt County, but in that case, Mr. Monning represented one of two sisters who had inherited a house from their mother. Taxes had not been paid on that property in the amount of $5,800, and the beneficiaries and sisters were either unable or unwilling to pay the taxes. The court appointed me as receiver and instructed me to proceed to sell the mother's home, and the back taxes were to be paid, and that the remaining proceeds would be distributed to the beneficiaries of the estate. I did not have a deadline on this sale, but I was able to complete that work within 90 days. I heard from Mr. Monning around November 29th, and he had asked that he is now representing an heir in a new receivership. The court had a deadline for completion of the sale, and that would be required to get the sale closed within 150 days. I told him I would do my best. The property involved in this case, unlike the case I handled last year, was not residential. It was an unimproved 175 acres in the south end of the county near Curtis Creek Park. The record title to the property dated back to 1938, and the record holder had died many years ago without a will. There were dozens of heirs, some owning as 1/123rd interest. Mr. Monning's client owned the largest interest in the property, 2/9 interest. Another two heirs owned a 1/9 interest. There were many others that owned even smaller interests in the ancestors' land. Knowing that I had a 150-day deadline, I started work immediately, but I was unable to formally list the property on the MLS or Lands of America until I received a copy of the court's order appointing me and had filed my oath and bond. After looking at the property, I determined that the property should be listed for a sale of around $3,500 per acre. I was aware of other properties in the area that had sold and were listed for sale in greater amounts, and that the appraisal district had increased the valuation of the property over the years from $2,100 an acre in 2015 to $4,200 per acre in 2020. But the property has been unimproved and had been lying out for a long time. It has lost its K1A open space valuation as agricultural land, I believe around 2014. As a result, the taxes have gone up from a few $100 annually to over $14,700 annually. This property also sustained substantial damage from a tornado that blew through the area 2 years ago. The property also is split by a natural gas pipeline easement that appears to be a pumping or pressure station. There is also an existing year-to-year hunting lease on the property. Very shortly after I received receivership, I did get a call from Justin Weems. Mr. Weems then told me that he had a contract for one of the heirs to purchase the property at a price of $400,000. I told him that I was a receiver and was not willing to sell the property under the contract, the price of 30, and that the new price per acre was now $3,500 per acre. I had learned from Mr. Monning that Mr. Weems had filed a claim in the lawsuit seeking to enforce his claim under the $400,000 contract. And following some discussion, Mr. Weems submitted a new offer, agreeing to pay the asking price of $614,250 and agreeing to waive any commission and to dismiss his claim under the $400,000 contract. I accepted that offer and submitted the report of sale that is set for hearing today. Mr. Monning prepared that report of sale for me. Mr. Weems has deposited his earnest money of $50,000 with the title company. I have received a number of other offers, both before and after the report of sale. An offer from a John Bush for $575 before the sale, another of $650, and I gather there's been another report. It had included an earnest money of $500,000 in commission. An offer of Burton Gale for $614 with a 30-day option to terminate. An offer from Joe Pratt for $614,250. Offer from Mark and Crystal Tulloch for $621 after the report of sale. An offer from $2 Pistol for $625 after the report of sale with a 10-day option to terminate. And then the offer from Rex Smith for $743, $750, subject to buyer's commission and an option to terminate. Although I have received offers for more money, I continue to believe that the offer from Mr. Weems should be approved. Mr. Weems has had the property under contract for over 2 years, has deposited $50,000 in earnest money with title, and has appeared in this case. I am concerned that if another offer submitted by the other parties made after the report of sale, which include contingencies, option periods to terminate, smaller earnest monies, may not be able to close in light of Mr. Weems' existing contract and notice of less pendants. I'm confident Mr. Weems is ready, willing, and able to close the sale in order to ensure that the long past due taxes are paid and that all the heirs of Mr. Abrams receive a substantial inheritance from their fathers, their grandfathers, and their great-grandfathers.
Council, are there any questions for Ms. Seifer?
Nothing from
No,
me.
Your Honor.
No.
Mr. Brand?
Nothing, Your Honor.
So all parties are in agreement that the court should should accept the report of Ms. Seifer as receiver and should order the sale of this property to Mr. Weems for that contract price of $614,250. Is that correct, Mr. Elliott?
Yes, Your Honor.
Mr. Brand?
Yes, Your Honor.
And of course, you want that, Mr. Shackelford, correct?
Yes, Your Honor.
All right. Is there anything further that the court should be aware of regarding the report of sale on this case?
Judge, I think Mr. Kellum is in the room. He's
He
also
is.
already, and he has already signed the order.
Mr. Kellum, can you hear the court?
Yes, Your Honor.
Okay. And Mr. Kellum, do you have any objection to the report of sale by Ms. Seifert? Do you have any objection to the court ordering the sale of this property to Mr. Weems for that sales price mentioned by the court?
I do not.
Okay. So from the court's position, everyone's in agreement that this has gone from a public tax sale to a private sale to this individual for this price. Am I correct on that?
It's my understanding, Judge.
Well, it was initially a private contract, and then there were the tax issues, and so then it went to the tax sale, and now it's back to a private sale, Your Honor. So yes.
Thank you for that, Mr. Shackelford. And just so that I can, as I think I've mentioned this to council before, my office has been receiving unsolicited contracts, bids, I guess, or for this property by various real estate agents or brokers. And at all times, I've had my coordinator forward those to council. And I'm assuming council then send it to the receiver so that everyone would be on the same page. But as of today, I did receive delivered to my office a farm and ranch contract from John Lee Bush for the offered amount of $750,000. All right, Ms. Seifert, were you aware of that before your report of sale or after your report of sale?
After the report of sale.
Okay, and Ms. Seifert, have you received multiple offers from Mr. Bush?
I've received two. I
Right, I
think
believe-
one you would receive today in your office, but I did not receive that.
So you're aware of two, and I believe you said 575 and
575 first, 650, and then I guess you've received another.
okay. And with that knowledge, is it still your assertion to the court that you believe that Mr. Weems should be able to buy this property?
Yes, Your Honor.
Okay. All right, if there is nothing further, then based on the agreements of the parties, the court will accept the report of sale from Ms. Paula Seifert as the court's appointed receiver. The court will approve that and order Ms. Seifert to move forward with selling the property to Mr. Weems at the price of $614,250. Mr. Monning or Mr. Elliott, will you be assisting Ms. Seifert with the orders necessary for her to complete her?
I have prepared a form of order, and it has been signed by Mr. Brand and Mr. Kellum and Mr. Shackelford. And if Mr. Kellum and Mr. Elliott will authorize me to electronically sign their names, I can file it here in 5 or 10 minutes.
I'll do that right now, Judge.
Mr. Keller?
Corey?
Yes, that's perfectly fine.
Okay. All right. Then upon receiving that order, the court will sign that and circulate it back to the parties. And that'll be e-filed, correct, Mr. Monning?
It'll be e-filed in a few minutes.
Yes, sir. Court will wait and look for that and we'll sign it today. And when is the anticipated closing date on this? I believe I saw in your report
29,
for the 21st?
29 of January.
29th. Okay. All right. If there's nothing further then for the court to take up, then the court will wait for that order. We'll sign that and then we'll be adjourned in this matter.
Thank you.
Thank you.
Raymond, would you call me on the phone, please?
Yes, Prater, I will.
Okay, bye-bye.
Thank you.
Have a good day. Yes, sir. You're excused. You have a good day.
Thank you, Judge.